Hello, everybody. Welcome in. Give it a minute or so to let everybody trickle in, but it's great to see so many of you here already. Hello, hello, welcome in. All right, I'll go ahead and get started. Hello, everyone. Good morning, good afternoon, good evening, from wherever you are joining us from in the world. My name is Sarah Viken, and I'm the Manager of Education here at the Environmental Law Institute. Thank you so much for joining us, and welcome back to ELI in the UN Environmental Program series about the report, Environmental Rule of Law, Tracking Progress and Charting Future Directions. Today's session will be all about climate change and environmental rule of law. We have a fantastic program lined up for you today, with panelists from across the globe gathered for a discussion on how climate change has become both a context for and a driver of environmental rule of law. We'll kick off the session with our moderators, Carl Brook and Lydia Slobodian. Carl is a senior attorney here at ELI, the director of our international programs, as well as president of the Environmental Peacebuilding Association. And Lydia is an adjunct professor of law and the director of the Georgetown University Law Center's Environmental Law and Policy Program. Carl and Lydia were both also contributors to the UNEP report, which you can find the link to on the event webpage, and I'll put that in the chat momentarily. Today's program will also be recorded, so if you can't stay for the entire program, it'll be posted on the event webpage for our members within a few business days. Now, this program will begin with opening remarks from each of our speakers, followed by a roundtable discussion, and we will be taking plenty of audience questions. So please submit those questions at any time throughout the program using Zoom's Q&A function. You can find that right at the bottom of your screen. It should say Q&A. And our moderators will be tracking it from there. The chat is also open for observations and comments, and we welcome anyone to put anything in there as well, but make sure you're just also putting those questions in that Q&A box. Thank you to Carl and Lydia for facilitating today's program, and to all of our wonderful speakers for joining us. And with that, I'll turn it over to you, Lydia, to get us started.
Thank you so much, Sarah. So today we're going to be talking about environmental rule of law. Environmental rule of law, very simply, is rule of law applied in the environmental context. We'll hear a bit more about that definition and why environmental rule of law is so important from our first speaker a bit later. We in the international community have been talking about environmental rule of law for several years now. UNEP came out with the first environmental rule of law report in 2019, and then the second report just last year. In the second report, we really tried to take stock of the status of environmental rule of law in different countries, laws and institutions, but also the ways that they were implementing environmental rule of law in practice. We wanted to identify trends, and we also made the decision to look at certain cross-cutting themes that went across the basic aspects of environmental rule of law, laws and institutions, rights, justice, and civic engagement. So across those four kind of aspects of environmental rule of law, we looked at a set of cross-cutting themes that we thought really identified environmental rule of law in this moment, showed something of what's happening right now at that time in 2023 and now 2024. And so those four themes that we really focused on were the COVID pandemic and the relationship between environmental rule of law and health. Second, social justice, including racial justice. Third, climate change. And fourth, technology. In this webinar, we're going to zoom in even more onto that theme of climate change and the relationship between climate change and environmental rule of law. And we've brought together some amazing speakers to talk about that relationship between climate change and environmental rule of law. Talk a little bit more and kind of give an overview of that relationship, and also answer the question, why climate change, of all of the environmental issues we should focus on. I'm going to turn it over to co-moderator Carl Brook.
Thank you, and welcome everyone. As Lydia noted, climate change was one of the dominant themes in the second environmental rule of law report. It was not a new issue. This has been something that's been in the space for quite a while. And so, but we were trying to say in the second report, what is driving environmental rule of law? What is affecting environmental rule of law, sometimes for the worse? And COVID was one of those for the worse, largely for the worse. But climate is, while it wasn't new, it was a dominant feature. And we saw that as we looked at the different dimensions of environmental rule of law, the development of fairly promulgated and equitable laws, much of the development of national legislation globally was in the space of climate change, whether it was mitigation or adaptation. Similarly, when we were looking at the linkages between human rights and the environment, constitutional rights in the environment, climate change was a dominant feature. And for civic engagement, this was the space where there was a lot of civic activism. And when it came to court cases, there were an overwhelming number of court cases that related to climate change, trying to often propel governments to take action, sometimes trying to hold polluters accountable. And I'm delighted that we have Maria Antonia here, because the Sabin Center has been doing a lot of the groundwork to track that legislation and the litigation, I should say. So in short, the reason climate change was such a feature was that so much of the focus on environmental rule of law, the different dimensions of it, is happening in the context of climate change. That's not the only space, and we highlighted other areas, including biodiversity and pollution, the triple planetary crises, but the climate change really was where most of the legislative activism and litigation was happening. I now have the honor of introducing our distinguished panel. Valentina Rica is an associate legal officer in the United Nations Environment Program Law Division, Montevideo Coordination Delivery Unit, which provides technical support and capacity building activities for member states on environmental law. Christina Voigt is a professor of law at the University of Oslo's Department of Public and International Law. She is also the chair of the IUCN Commission on Environmental Law, and the first co-chair of the Paris Agreement Compliance and Implementation Committee. Maria Antonia Tigre is the director of Global Climate Change Litigation at the Sabin Center for Climate Change Law at the Columbia Law School. She also manages the center's Global Climate Change Litigation Database and heads their project with the Global Network for Human Rights in the Environment on climate litigation in the Global South. Lisa Osorio is a professor at the University of Cebu School of Law, where she teaches environmental law courses. She is also a managing trustee of the Philippine Earth Justice Center and a legal and policy consultant at Oceana Philippines and Rare Philippines. Lisa was an author of the second Global Report. And Jorge Daniel Tallant is the executive director of the Commission for Environmental Cooperation, where he pushes for more effective public policy, stronger legislation, and greater corporate accountability and respect for human rights and environmental sustainability. Notably, Daniel has also been a leading litigator at the intersection of environment and human rights for decades, and we are delighted that he's able to join us. And with that brief introduction, I'd like to turn the floor over to Valentina.
Thank you very much, Carl, for giving me the floor. I'm delighted to join this critical conversation on climate change and the environmental rule of law, which is relevant to most of the aspects discussed in the UNEP second environmental rule of law report. To give some context, environmental rule of law, as Lydia said, is an evolving concept generally understood as the principles of rule of law applied in the environmental context. It refers to a governance system in which all public and private individuals are held accountable to public laws, equally enforced, independently adjudicated, and consistent with human rights. In recent years, climate change has become a subject of public recognition and concern, given increased reporting, a wave of policymaking and litigation directed at addressing it, which have accompanied public awareness of the problem. For example, the UK Public Attitudes Tracker witnessed a significant increase from 23% in 2017 to 43% in 2021 of people who say they are very concerned about climate change. As public awareness increases, the world has also seen a rise in civic engagement with climate activist groups, including youth and indigenous peoples, at the forefront of climate action and protest. And in this context, climate change is acting as a powerful driver for environmental rule of law in three key ways. It is driving legislative reforms globally. It is promoting the integration of environmental concerns into human rights frameworks, and it is leading to more judicial actions that hold governments and corporations accountable for climate commitments. On the first point, climate change not only acts as a context for legal and regulatory developments, but has become a powerful driver for legislative change. Climate change international instruments and frameworks like the Paris Agreement have inspired and informed an increase in national climate legislation and governance frameworks with many countries such as Algeria, Bolivia, Cote d'Ivoire, Cuba, Dominican Republic, Ecuador, Thailand, Tunisia, Venezuela, embedding climate responsibilities into their constitutions. Also, between 2019 and 2021, there was a rapid expansion of national and subnational climate laws and regulations in several countries, such as Argentina, France, Germany, Mauritius, Spain, and the Russian Federation. On the second point, human rights mechanisms and institutions continue to play an essential role in integrating environmental issues such as climate change into human rights frameworks. At a global level, the Universal Periodic Review of the UN Human Rights Council allows the global community and civil society to scrutinize the extent to which states fulfill their international human rights obligations. About 46 of the national reports submitted discussed issues like climate resilience and disaster management. National human rights institutions have started linking climate change to human rights as well, and in 2020, the Global Alliance of National Human Rights Institutions adopted a statement calling for a human rights-based approach to addressing climate change, emphasizing the need to include vulnerable groups and especially women and indigenous peoples. Also, bodies such as the UN Environment Assembly, UNEA, adopted resolutions recognizing these linkages, and several human rights treaty bodies are now urging states to address climate change within the scope of their human rights obligations. On the third point, courts around the world have become critical in holding governments accountable for climate action. A sharp increase of judicial actions on climate change has been observed. As of July 2023, the Sabin Center for Climate Change Law's litigation database recorded at least 2,369 climate change court cases filed in 55 countries and international adjudicatory bodies. This critical role of courts is encouraged and informed by the failure of other government branches to address climate change. In most countries, indeed, climate legislation still has to be adopted, creating a gap in legislative frameworks, which causes people and public interest litigation organizations to bring cases to court premised on constitutional rights, human rights, and other legal bases. Courts are often asked to order the adoption of ambitious climate goals backed by climate change frameworks, and the Urgenda Foundation versus Netherlands case is a landmark example of this, where the Dutch courts ordered the government to cut emissions more ambitiously. And similarly, the Tribunal for the Law of the Sea recently delivered an advisory opinion confirming that states must take action to control marine pollution from greenhouse gases. Moreover, courts are increasingly holding the private sector accountable for its emissions. For example, as of July 2023, more than 40 states and municipalities in the US have filed lawsuits against corporations. To conclude, it's clear that climate change not only provides context, but also drives the development of the environmental rule of law, sparking legislative, institutional, and judicial actions globally. Human rights mechanisms play a crucial role in integrating and protecting environmental human rights, while courts continue to spur climate action to aid the failure of other government branches to address the climate crisis. I wish you a meaningful and fruitful discussion. Thank you.
Thank you very much. Christina, the floor is yours.
Thank you, Carl. And before I start, I'd like to congratulate the United Nations Environment Programme and Valentina and her team on that second report, as well as you, Carl, and Lydia and Rose, and everyone who contributed to this very important publication. Now, I will try to use my couple of minutes to speak about the international aspect of the environmental rule of law, and that's when it comes to climate change. And that's not an easy topic because the rule of law in international law is quite an elusive concept because we don't have necessarily that situation that we have a sovereign and those that are governed, and the rule of law addresses that relationship. But in international law, we have equal sovereigns that need to figure out how to relate to each other. So when we talk about the rule of law in international law, I embrace the concept of a rule of law in a globalized world. And here, addressing the environmental aspects that a globalized world needs to be addressed as an understanding of the environmental rule of law when it comes to international law. Now, just one step back on climate change and why we need international law as an aspect of the environmental rule of law. When Valentina already and Carl, you as well addressed the climate change is a collective action problem. Climate change is caused by a myriad of actions, and not just all over the world, but also over a very long time frame. That makes it like a double challenge when it comes to collective causation. And because of that, the only way forward really on the international level is to find a means for global cooperation, and that through international legal tools in order to create predictability, in order to create a fair and equitable sharing of benefits and efforts, but also to ensure that whatever we come up with internationally also has the chance to be effective. Now, an international response to climate change also needs to be multifaceted. It's not only about reducing greenhouse gas emissions, although addressing the cause of the problem needs to be a priority, but we also need to deal with adaptation because climate change is happening. It is at our doorstep, as we've seen just recently in Florida. And it needs to address losses and damages that happen where we cannot adapt to the changes that are already occurring, but also needs to have aspects of finance, aspects of transparency, monitoring, the issue of reporting and verification. All these aspects need to be packed together. And for that reason, the only way forward really is to establish an international legal framework and implement effectively what we have in order then to let it trickle down to the national level. International law is also important in the context of climate change in order to avoid free riding, right? In order to avoid pollution havens where polluting activities can continue unhampered. And it gives us a direction of travel in order to inform domestic litigation and the domestic legislation on what needs to be done on the domestic sphere with respect to climate change. Now, what do we have in international law? We're all aware of the Paris Agreement, and I don't want to lecture about it, but the importance of the Paris Agreement is that it gave us that direction of travel, which we now see, and Valentina addressed that, we now see this informing many domestic laws, but also many cases domestically in the interpretation of either constitutional provisions or human rights provisions or what have you. So especially the temperature goal, the Paris Agreement of holding temperature increases to well below 2 degrees and 1.5 degrees is something that we've seen repeatedly referred to in many decisions by many different courts. But increasingly also the other goals of the Paris Agreement, there's an adaptation goal as well as a finance goal about making finance flows consistent with low greenhouse gas and climate resilient development, which could potentially be a very potent normative element in interpreting, for example, trade or investment streams. Now, we all know that every single state has to put forward an NDC, nationally determined contribution, every 5 years, and an NDC needs to progress in the level of ambition to the level of highest possible ambition. And the next time this is due on the 10th of February next year, where as a part of a legal obligation, every member state to the Paris Agreement has to put forward its NDC. At the same time, or a little bit earlier, on the 31st of December this year, every member state to the Paris Agreement has to provide information on how well it is implementing and progressing in the achievement in its NDC. And these are parts of the legal framework that are just about to kick in motion that we haven't seen yet, and that will, of course, hold also a lot of potential to inform domestic litigation and legislation, as well as most likely also international and domestic court cases. But we have more than the Paris Agreement, and I think Valentina mentioned as well. Independently of the Paris Agreement, we have other international treaties that do contain obligations to address climate change. We know now from the European Court on Human Rights in the Klimasenioren case that, for example, Switzerland and all the member states of the European Convention on Human Rights have an obligation to reduce greenhouse gas emissions and to adopt effective climate mitigation measures as part of their positive obligation under the European Convention on Human Rights to protect either right to life under Article 2 or the right to private life. And not only that, it is also clear from the judgment from the European Court on Human Rights, again, the direction of travel, because the European Court used the Paris Agreement in interpreting the European Convention on Human Rights, which doesn't even mention the word environment, let alone climate change, anywhere in its legal text. So in order to give more content to the legal obligation, the court referred to the Paris Agreement and established the legal obligation under the European Convention on Human Rights to reach climate neutrality by 2050 and to adopt long-term but also intermediate climate targets, as well as their effective implementation. That's an independent legal obligation from the Paris Agreement, though informed by the standard that we find in the Paris Agreement on the basis of the European Convention on Human Rights. And a third example, one that Valentina just mentioned, is the United Nations Convention on the Law of the Sea, where we now know from the International Tribunal on Law of the Sea in its advisory opinion that was issued on the 21st of May this year, that states do have a legal obligation under Article 194 to prevent, reduce, and control pollution of the marine environment, and anthropogenic greenhouse gas emissions from all sources were considered to be pollution of the marine environment. And again, the Tribunal of the Law of the Sea used the Paris Agreement in the interpretation of the United Nations Convention on the Law of the Sea, which does not address climate change or mention greenhouse gas emissions, but it used in the interpretation the Paris Agreement and established that states need to address and control marine pollution by greenhouse gases in light of the 1.5 degree temperature target of the Paris Agreement, as well as the corresponding emission timelines and pathways. And then we're back to net zero emissions by 2050, which was based on the Paris Agreement. So we see the Paris Agreement that direction of travel that I mentioned in the beginning now making its way into the interpretation of other international treaty and other separate bases for legal obligations and other treaties for states to reduce greenhouse gas emissions. And I think with that, we see an emerging standard, 1.5 degrees, net zero by 2050, intermediate and long-term targets, updating whenever science tells us, but also effective implementation that we see coming through across different international courts and strongly informs the action that states need to take on the domestic level, including the due diligence they have to exercise also with respect to regulating the private sector, something that Valentina just mentioned. And I think we will probably hear much more from the International Court of Justice once it issues its advisory opinion. We all know that the oral proceedings will start on the 2nd of December and they will last until the 13th of December because I'm the legal counsel for the IUCN and we've got the very last slot of the oral proceeding, which is on the 13th of December at 4:45 p.m. By then, we will have heard 100 interventions from states and international organizations. And I'm sure the court will be well prepared to render its advisory opinion at some point in 2025. And we'll go through different international treaty obligations as well as customary international law, which is another very exciting element with respect to legal obligations to address climate change. And we will see, most likely, the environmental rule of law becoming more refined with respect to climate change once all the advisory opinions are in. And with that, thank you, and back to you, Carl.
Thank you, Christina. And Maria Antonia, the floor is yours.
Thank you so much. It's really a big pleasure to be here. And I was very happy to see this report and see the interaction that it has with the UNEP report on climate change litigation, which the Sabin Center writes along with UNEP. So it's really exciting to see climate litigation being recognized more and more as, it was recognized by the IPCC as an effective form of changing behavior, of changing the ambition of states, and now being recognized as a crucial part of environmental rule of law and of implementation as well. So, I think one of the interesting things about climate litigation is that it's always changing. So I think whenever I have to prepare to do a new presentation, something else happens that needs to be adapted and it needs to be mentioned. So it's sort of a very fast pacing environment. And now we have over 2,800 cases, who I think by the end of the year will reach 3,000, which is definitely, it's a lot. It's a lot to digest. It's a lot to interpret, but it's really exciting to see so many courts around the world really starting to engage with that and seeing how that movement across jurisdictions happens as well, right? So one jurisdiction really being inspired by others and trying to then reach similar results across the world. So I think there, a lot has been said already and a lot of really great examples of climate litigation, but I'll mention a couple of things that I think are important within this context. I think, first of all, the constitutional basis that Carl had mentioned in the beginning, I think, the rights-based cases is really obviously a portion of the climate litigation cases of this universe of almost 3,000 cases that we have nowadays, but it's such a visible category of cases, right? Because you can really see the human aspect of it. You can really see the effect that it has on people. And like Christina was saying, there's this possibility of really using legal mechanisms that, laws and domestic laws and international treaties that have been around for decades to then implement further engagement with climate change and climate change protection, right? Because I think, it was also mentioned in the beginning how climate litigation really is emerging because of this lack of ambition by states in general. And using, and part of that is really using these innovative strategies to adapt what we have, because we don't have the necessary laws, to get to the results that we need to reach, right? So I think part of that innovation is really what's interesting to see in climate litigation. And I think that relates a lot with the rule of law, because it's finding innovative ways to get to the results that we need with whatever tools that we have, right? Sorry, I have this bad cold that I'm recovering from. So talking a lot is not great for my voice, but so then, part of that is, like I said, using these international laws and treaties and the domestic laws as well. But then obviously this whole movement of the constitutional right to a healthy environment that also spread around the world in the recent decades has really helped spearhead that as well. I think another important thing that was briefly mentioned today that should be noted is this aspect of activism, which obviously relates to bringing these innovative cases. But I think part of it, sorry, part of what's really interesting is seeing how activists around the world are really using climate litigation as one of the tools in their arsenal, right? So this has been used by indigenous groups around the world. It's been used by children around the world. So really, I think there's this recognition that even though, I guess, bringing a legal case would be too far-fetched a couple of years ago for certain communities, I think now it has really become, it started to become part of their practice in that judicial activism. And there's a really excellent handbook on climate activism that's coming out in the beginning of the year that has 40 chapters talking about climate activism around the world. And I wrote with a couple of colleagues from Client Earth one of the chapters on climate litigation as climate activism. And I think it's interesting to think about from that other perspective as well, right? Because I think for me, because I manage the database and I'm looking at it always from a sort of a more academic perspective and from a more objective view, looking at it from the angle of who's bringing these cases is also really, really interesting. And then the other thing that I wanted to mention is that climate litigation also has a lot of indirect effects that are not often talked about, and mostly because they're really hard to track and to understand. And enforcement of the judicial decisions in and of itself is already hard to track, because it can be, it depends a lot, obviously, on the relief that was granted, but it can mean it can be either a law being adopted, but it can be things that happen throughout a couple of years after the decision was granted, right? So there's a challenge in that, which the environmental rule of law is really crucial in addressing. But also even the filing of a case sometimes already brings about certain changes in government behavior and corporate behavior, and the threat of bringing cases in and of itself is also, it also has certain effects. So there are cases that I guess that don't ever get to be in cases, but there's the threat that happens there that already encourages certain behaviors and reaches the desired outcome because of the strength of climate litigation nowadays. Yeah, so I think I'll leave it at that for now, and I'm happy to talk more as we move forward.
Thank you, Maria Antonia. And Lisa, the floor is yours.
Thank you. Thank you for having me. Well, just to provide an update, since I became part of the group that wrote the second environmental rule of law report, I've already joined Oceana as the senior director for campaigns, legal, and policy, and now also at the same time still working as an academic teaching environmental law in the Philippines. I will bring with me, a perspective coming from Asia, the context of environmental rule of law in Asia, where I am right now and where I live. countries in Asia faced significant climate risks, particularly among developing nations with limited adaptive capacities. And if you look at the state of the climate in Asia report in 2023, it highlighted the accelerating rate of key climate change indicators such as surface temperature, glacier retreat, and sea level rise in the Asian region. So Asia remains the world's most disaster hit region from weather, although some of this might have changed already in recent weeks, but we still have a lot of climate and water related hazards in 2023. And looking at the legal and institutional framework in Asia, most countries actually still have limited robust climate laws and litigation frameworks, but we can also see that there's a um, growing cases, a number of cases and litigation and legal developments in Asia. Like for instance, in China, the introduction of public interest litigation in civil law has led to lawsuits for environmental damage. In Indonesia, the government was held liable for air pollution by failing to protect the citizens' right to clean air. In the Philippines, Pakistan, and India, the courts have been used where judicial tools are applied to ensure compliance with environmental orders, such as the writ of continuum mandamus and the writ of kalikasan or nature in the Philippines. So these judicial tools are essential in monitoring strict compliance of court orders. So it has gone beyond and above and beyond just merely releasing an order to do their legal mandates as they are commanded to for government in countries like Philippines. Um, then there are also transnational actions that integrate climate change into the human rights framework, such as the investigations by the Philippine Commission on Human Rights that looked into the human rights violation linked to major polluters after Super Typhoon Haiyan. So because we've seen in Asia that environmental laws and institutions still provide the very foundation for environmental rule of law. And in the growing number of cases, climate change now becomes a central focus for efforts to strengthen environmental rule of law and serving as a key driver for legal actions. Um, and we've seen that courts are increasingly becoming effective in our part of the world where innovative remedies in environmental cases are employed. In my work, I work with local communities, in preparing litigation and explaining to them, educating communities, and there are growing number of interested sectors in employing these legal tools to ensure that, for instance, legal gaps are addressed through decisions of the courts of justice. So environmental rule of law really is a key principle that has been transformed from just mere theory to practice in many of these cases. But we need to develop a better legal and policy framework still, especially in Asia. Um, while we've seen that the recognition and integration of environmental rights has accelerated as based on the report and a survey of 193 countries, Southeast Asia needs to still move forward. For instance, where I am, but it's a good thing that we've seen now that there's a move to create an ASEAN regional framework on environmental rights that guarantees a safe and secure environment for all stakeholders to exercise their rights. And so this is, really crucial, especially in countries where there's weak enforcement of environmental laws, poor environmental governance. It provides a good starting point for legal actions and remedies that citizens can use to assert environmental rule of law. Finally, I'd just like to also share with you that there's really a growing call for corporate accountability and mechanisms to address climate-related loss and damage. But with all this growing demand for laws and legal actions where we can integrate loss and damage mechanisms. Um, some of the recommendations include also that in these laws, we should incorporate also indigenous perspectives or community perspectives into climate accountability, and also recognize, legal pluralism which is very, very much evident in many countries in Asia. So, a respect for customary laws, traditional tools, should be, part of the growing framework for demanding and recognizing, for instance, environmental rights and seeking for loss and damage mechanisms or solutions for local communities. Thank you.
Thank you, Lisa. And before I turn the floor over to Daniel, I wanted to invite people to submit any questions they have in the chat, and we will start on those following Daniel's remarks. But Daniel, the floor is yours.
Thank you so much, Carl. So first point of order, I'd like to make just a small correction to Carl's introduction. And I say it just for the record, but also because it's important to my comments. And that is that I'm not technically a litigator, I'm not a lawyer, but I have led a group of lawyers in an organization that ran a legal clinic and a legislative clinic. And I'll point to this as an important consideration. So I guess the first thought that I'd like to throw out there is an emphasis on the fact that law follows custom, right? And that we can't speak of the enforcement of the rule or environmental rule of law in the abstract. It is always in evolution, and law and policies and declarations and agreements, they all depend on this evolution of society's assigned priorities to what is important. And generally, perhaps usually, the law is behind our priorities. And as we are developing these priorities and as we create new priorities, the law catches up. We don't wake up one day and link climate change and human rights. That's not how international law works. It's not how national law works, and it's not how we develop our policy. And a few examples would be, for example, when we first started, or I first started in my career in this field, getting organizations and governments to link human rights and environment. If you go back to the early resolutions when we got adopted in the Organization of American States at the Inter-American Commission on Human Rights and their discussion, if you read that resolution, that was 1819, the first paragraph says, we're going to look at whether or not there is a link between human rights and environment. It's perhaps startling to read that today, but that's how law begins. That's how international law begins, and we work to improve over time. The same goes for the rights-based approach to development, which in those years was also getting off the ground, or the work that was done on human rights in business, where corporations were reluctant and actually outright resistant, and even governments were resistant to accept that corporations had any responsibilities over human rights. We ended up with the UN principles on business and human rights as a sort of intermediary agreement on how we were going to deal with human rights in business. But again, this is it's a tug, it's a back and forth between various actors about what's important, what society is prioritizing, what becomes a priority not only in policy but also in law. And you might look at new debates on the intersectional dimensions of climate change, environmental justice, gender, sexual orientation, age, migratory status. I mean, these are all things that are becoming important as we discuss climate change. And these are the beginnings of discussions, much like others were decades before. I'd also like to suggest that in the sense that environmental law is not simply a concept that's in a law professor's lecture or an abstract concept in a law book, it is the result of different actors of society working together. And as such, we need to be strategic about advocacy around promoting environmental law and the enforcement of environmental law and the rule of law. Judges don't wake up one day and rule one way or another because they were inspired during their sleep. They receive stimulus from society. There's media. There's education happening. We need to train judges, or even perhaps more importantly, their clerks. We need to really think about what is it that takes a judge or court or legal system to rule one way or another. And we can't think in the abstract, and that's absolutely fundamental. So in that sense, we also, in the strategic advocacy approach to the rule of law, we must be careful. And we certainly must think outside the legal box, but careful in the sense of making sure that our actions and what we're doing doesn't set the wrong precedent. You know, it's very hard to reverse precedent once things have gone the wrong way. And so we need to think about environmental law and the rule of law in the context of this evolving process. I'd like to turn to think a little bit about the climate emergency, and it's already been mentioned, the triple planetary crisis. And these are frameworks that we use because they're convenient, because we understand them to be helpful in the way that we are approaching issues. The reference to the Paris Agreement was made and the importance of 1.5C, and that has really helped us set that framework for how we think about climate change. And it's critically important to understand that framework and what it means and its relationship to the science. The science is actually extremely important. And here's a flag I'd like to raise because the science is also very clear about what is important and what is priority today. And we don't always take these into account when we're thinking about our strategies and about the way that we're addressing environmental law as it relates to climate change. The science is telling us that we're not on the 1.5 pathway. And this means something, and it's actually quite important, because if we're not on the pathway, the conclusion or the end of the pathway is that we trigger tipping points that are irreversible. And these tipping points are important. They matter a lot because each 1/10 of a degree that the temperature goes up, there's more suffering, there's more violations of human rights, there's more pain, there's more impact, there's more vulnerability. So it's not the same to aim for 1.5 or 2.0 or 3.0. And then also it's not the same when we look at the policies that we implement to address either mitigation or adaptation. Because if we are making the wrong decisions, if society as a whole or a government in particular or a particular public policy is not aligned with that science, then we get into these paradoxes that are actually quite tragic in that we think we're acting correctly for climate change. We think that we're advocating correctly. We think that we're working to enforce environmental law or climate targets, but in fact, we're condemning future generations to further suffering or collapse. And so what we decide to focus on in terms of pushing for the enforcement of environmental law is extremely important. And where the issues today are really centered on is getting this balance between mitigation and adaptation. But then there's the question, what if we miss the mitigation targets? Because at the end of the day, if the mitigation is missed and we're headed to 2.0 or 3.0 C, then we're condemning future generations to further pain and suffering. And so what is chosen for our action is critical. And I'd like to close with a reflection on the work here at the CC. We have a process called the Submission of Enforcement Matters, and it's basically an agreement of the US, Canada, and Mexico to work together to ensure the enforcement of our environmental laws. And it's a space in which any individual from North America can submit that one of the countries is not effectively enforcing its environmental laws. And I think here it's worth noting this is an extremely important mechanism because it really gets at the procedural elements of the rule of law. It's about access to information. It's about participation. It's about individuals' ability not only to question the compliance of environmental law, but also to really realize the elements of the implementation of that law. And a lot of the cases that you see are about this. The SEM has been in existence for 3 decades now, and it's become a model for other treaty frameworks to consider enforcement of environmental law. And I welcome all of you to take a look at it as an interesting and very effective mechanism through which we can think about how individuals in a given country or across a region are actually able to realize the rule of law. Thank you.
Thank you. Lydia, would you like to start the discussion period?
Absolutely. So huge thanks to all of our panelists. So much to think about. Thank you to those who've already put some questions in the webinar chat and in the question and answer box. Please continue to do that. We'll get to those in a second, but I want to use my prerogative as moderator to quickly ask one or two questions of our panelists. So the first question is, Daniel touched on this slightly. In dealing with the problems of climate change, we're dealing with a lot of uncertainty, scientific uncertainty, technological uncertainty, legal uncertainty, and this has been a barrier to effective implementation of environmental law. For example, the way we've seen in court cases, the problem of causation. How can we adapt environmental rule of law, or better use environmental rule of law to address the uncertainty inherent in climate change? And Christina, if I may, I'd love to go to you because I know you have to jump off in a second.
Yeah, thanks, Lydia. And indeed, I have to leave in a moment. But your question is a very pertinent one, although I think that the margin of uncertainty is being reduced drastically by every IPCC report that's coming forward. And we actually do know so much more than we don't know when it comes to climate change. I do agree with you that maybe when it comes to the timing of local impacts, there may still be a certain degree of uncertainty, but we do understand the climate system, we understand the causes and effects, and we do know what needs to be done in order to stand a chance to hold warming somewhere close to 1.5 degrees. And we also do know, Jorge was talking about what would happen if we overshoot it and if we reach the tipping points. Crossing tipping points, we are entering an area of uncertainty where we don't really know how the different tipping points may relate to each other. But I think there's ample science to take the action that is needed. So I'm a little bit reluctant to say, oh, well, we have to address uncertainty when it comes to climate change. But where we do still have uncertainties, we have means to address them in terms of applying the precautionary principle, applying buffers, applying conservative estimates, applying, transparency across the whole scale of action so that potential uncertainties can be limited. So I think that there are various legal tools to address it, but also in the court cases that are coming forward, there is very little that deals with uncertainty, right? They're really straightforward and sometimes very bold statement by different judges saying, well, we have a carbon budget and that is being exhausted. And it's like, oh, well, interesting. So I think the problem does not necessarily lie with uncertainty, but where there are uncertainties, I think we have the legal tools at hand to address them. But I think the problem lies somewhere else. It lies really in mobilizing the political will to do what science tells us is necessary. And with that, I'm really sorry, but I have to leave. So thank you all for that wonderful webinar and all the luck for the rest of it. Thank you.
Thank you so much, Christina. Maria Antonia, do you have anything to add?
Yeah, no, I think Christina covered a lot, but I just wanted to say that I think certain decisions are also trying to link the developments in our knowledge as well. So rather than just making static recognitions based on the science, really recognizing that this changes constantly. So the ITLOS advisory opinion, for example, really clarified that IPCC reports are really the reference there. And obviously these are updated constantly. So linking to that type of thing, rather than just saying like the agenda decision, for example, which is so celebrated around the world, the standard that was adopted there nowadays is not really considered a good standard anymore of mitigation. So there's a lot more that obviously is being at least attempted in lots of cases around the world. So I think making that constant, like linking decisions to that constant revision of the science is really important as well.
Yeah, definitely. Lisa?
Yeah, I think from my experience, it's also important to, like, I think it was also mentioned earlier that we also go into the capacity building for judges and the courts as well, because I think in many of our cases, especially here in the Philippines, causation is really very, very difficult to prove. And I think we've seen, like, even if we have one of the most advanced rules of procedure for environmental cases, we just struggle to have our cases, and most of the time cases like the writ of kalikasan or nature cases are dismissed because of a failure to do the causation or to prove causation. And so we've also have some dialogue with our Supreme Court, and I think it's important that the courts are open to dialogue regarding these cases, and the willingness to be trained and to engage in capacity building activities for judges, for prosecutors, as well as as mentioned earlier, their legal clerks. And yeah, so capacity building is very important for us to also deal with and to effectively address this uncertainty.
Daniel?
Sorry?
Daniel, I saw that you unmuted yourself. Did you have?
Yes. So just a couple thoughts. I remember back in the day when we were just starting our legal clinic, we thought we were going to train judges. We quickly learned that judges don't get trained, right? And so our solution, we had several solutions. One was to train the clerks because they were hungry, young, and wanted to do the right thing. And the other was to train, to have the judges train. And that seems counterintuitive because you're trying to train the judges. But if you were able to bring some peers to the table where they felt obliged to level up, that was always a better solution. So they feel like they're the trainers. My point here is that they need help, right? Again, they don't work in abstract. We need to put up the pressure. We did at the time. We looked at all of the media covering environmental issues, and it wasn't covering them. So we trained the journalists, right? And so we did have a strategic approach to train and educate and disseminate ideas about the environment at the time that would end up influencing the judges, right? And so again, it has to be a bit more strategic than thinking in the abstract that through a legal box, you're going to solve the problems. Plus cases can, in different countries can take years, and we don't really have years, right, to work through the system. So we do need to be extremely strategic about where we invest the limited resources that we have and the time to get the most out of those investments. And that takes, it takes a little bit of stepping outside and trying to see the big picture, as opposed to thinking that one case is going to really change everything from then on forward.
Yeah, thank you. So I want to go to some of the questions in the chat, and I will echo what Sarah just wrote, that if you did just put your question in the chat, I might miss it. So please put it in the question and answer box. But I do see that Cheryl put a question in the chat. Has there been experience with implementation, and what have we learned about the formulation of these laws? So as we know, environmental rule of law is all about implementation. It's about addressing the implementation gap, but it can be really hard to find those actual concrete examples that give us the lessons learned. Carl.
Sorry, I just wanted to add on to that. Another one of Cheryl's questions that's directly related is she was asking about what legal frameworks are most effective in the context of holding corporations accountable. But I think more broadly, there's a very interesting question about what are effective legal frameworks and how do we know they're effective?
Yeah.
And I'm wondering if any of our panelists have thoughts on that, because I think that there's a lot of personal values and perspectives that come into that, but the evidence of effectiveness, how do you measure that? Because I think that's something that the environmental rule of law reports are trying to get at. And a lot of the indicators are based on certain theories of change, like citizen suits. And I'm just wondering if people could comment on, both, what countries have done in their legislation, and how do you know if it's effective?
Lisa.
Yeah. Yeah, I think Carl mentioned it, enabling citizens to file actions and also providing that constitutional framework where actions are sometimes usually rights-based actions. And so in countries where there is a constitutional recognition of the right to environment or a legal recognition of that, it's very, very important as a basis for starting or initiating that legal actions. I think, yeah, that's also very, very important because but of course, it will only be effective if the citizens know about it. And yeah, education is also very key because based on my experience, there's really really a need to educate and disseminate information in an effective manner as to how these actions can be used as a remedy for many of their for many of the victims of environmental damage and climate risks experience. And so I think, yeah, having that as like an initial basis is really very, very important.
Yeah. Daniel.
Yeah, so a couple of thoughts on effectiveness. I mean, effectiveness means that it gets you what you're looking for. It's not always the right legal remedy, right? Sometimes, we filed, I remember way back, if you're familiar with the Equator Principles, which aligns banks on certain safeguards to take into account, not enforceable, there's no mechanism, there's no complaint mechanism. We filed a fake complaint, and it resulted in $450 million being removed from an investment in a project. That was successful, and it was not even a legal complaint. There was a community involved in another case that involved international investment, and they filed a criminal complaint against not only the directors of the company, but they named the World Bank executive directors. And that got the World Bank really worried about whether or not they could travel to Argentina, for example. And so, that case never reached a verdict, and yet very effective, right? So you have to get away from this idea that you're going to file a case in court, you're going to get a ruling, and it's going to answer everything and solve your problem. It's more about where the influences are and who's reacting to what and where is the possibility of getting that change that you want. And this is, I think, part of the problem that we run into sometimes in the legal box, which is we think the effectiveness is getting a good ruling, right? And how many cases do we have that were never enforced or implemented afterward? And that is a weakness of the legal systems, when you might get a great ruling in the court, but if there's no implementation or enforcement of that ruling, you're not really helping the community or those that were the victims in the case.
Yeah. So that actually leads into a couple of other questions that I've seen in the chat and in the Q&A. One is, how can environmental rule of law help with the implementation of these rulings? Maria Antonia highlighted very clearly that implementation can be a problem. Can we use some of the tools of environmental rule of law to help with that? And then we had a question from Jonathan Wiener. Can you say more about the remedies the courts are developing and how they're addressing issues of expertise and of separation of powers? And he mentioned some of the US cases, like Juliana, which have faced dismissal over redressability and related doctrines limiting the power of courts to order the executive branch to take action. So I would love to hear what your thoughts on those, both how can e-roll support implementation of cases and what are courts doing with regards to remedies?
Should I start?
Would you? Thank
They're
you.
definitely very challenging questions, and these are topics that I think about very often. I think, first of all, the issue of implementation is directly linked to remedies. So obviously, I think the remedies that we have available now are often not appropriate for the strength of the climate crisis that we're facing, right? So that all needs to be revised as well. But at the same time, if there are remedies that are too bold, then you face this problem of like, how do we even start implementing this? And I think this is particularly difficult in the global South when, you know, sometimes they don't really have the capacity to implement whatever it is that the court has decided that they need to do. So I was, you know, talking to a lawyer the other day from Brazil, and she was talking about the floods that happened in the south of Brazil in the beginning of the year, which were really unprecedented and devastating, really got an entire state underwater. And somebody was saying, oh, we should bring a case against the government. And the government, the federal government, right? So the government did, obviously there are lots of things that are imperfect, but in addressing that, and you know, there's a lot of adaptation that can happen to avoid these things, right? But at the same time, when that disaster happened, they really tried to get all the money they needed to these communities to address the situation, and you know, trying to respond in the best way that they could. So if a case is brought against this government, who, you know, it's like, can argue that Brazil has a lot of money for certain reasons, but it's still a global South country. You know, there are definitely lots of capacity issues. So if there's a major lawsuit against the government with millions and millions of dollars that need to be paid, what happens, like with everything else, right? So I think there's a, you know, there's a balance that needs to be very well thought of when building these cases. So, you know, what this lawyer was saying, like, why don't we, instead of bringing a case against the government, bring a case against all the cattle ranching companies that are very big in this state in particular, that are responsible for these greenhouse emissions, and then could, you know, cover these costs of adaptation to avoid something like this happening again, or at least, you know, be better prepared for it. So, you know, there's a problem, I think, in relation to these things. So with the question of separation of powers, just very quickly, obviously this depends a lot from country to country. It varies quite a lot. Like my experience is that usually like common law countries, I see like the US, the UK, Canada, Australia, they're usually more like a little stricter with separation of powers, and most, like, there are lots of decisions that have you know, really, like, where courts have said, like, we can't really meddle in whatever the executive and legislative branches are doing, because that's really their prerogative to decide how we tackle climate change. However, I want to say that there was just a decision a couple of, you know, like in the summer from the UK, from the Supreme Court of the UK, which is, you know, usually a very traditional country in terms of climate litigation, saying that the environmental impact assessment of an oil project needed to include scope 3 emissions. So it was a really bold decision. There are not many decisions around the world that they include scope 3 emissions as part of the way that agencies need to assess climate harm, potential climate harm, and environmental impact assessments. So this is really one of the first ones that this did so, and it came from a country where you wouldn't normally expect that, mostly because of separation of powers. And then the last thing I want to say on that is that there was a decision from Brazil, I guess 2 years ago at this point, and I have a whole article talking about the decision. I talk about the decision every time that I talk about climate litigation. It's called Climate Fund Decision. It's an article that we published in the Georgetown International Law Journal. I can put it in the chat, in which the Supreme Court of Brazil said that it's not only the court, separation of powers should be viewed like sort of in the opposite way, in a sense. It was really the court's prerogative, duty to really engage whenever the executive government is not doing what they should in terms of protecting people against the harms of climate change and addressing climate action more broadly. And this was at a time when Brazil was really under a government that was very anti-climate. So obviously it's a special circumstance. But in that case, the court in that decision really made an effort to make that very clear, that it was really their duty to sort of tell the executive government what they needed to do, and that they needed to observe the law when they were not doing so. All right, and I'll leave it at that.
Yeah, Daniel?
Yeah, just a couple thoughts on, these big words we throw out like government and the judiciary, right? They're not monolithic. They're not singular entities. And we need to also be very careful and strategic and think about timing when opportunities arise. Sometimes ministers want litigation, right? Because it's not within their jurisdiction or within their budget or mandate to do something. But if they have a court order mandating it, then all of a sudden things change. And we'll see also that different judges in different jurisdictions function differently. And we need to think about those differences as we're planning out strategies, because again, if you choose wrongly, if you set bad precedent, or if you're asking for something or focusing on something that's going to be unrealistic in its implementation, then you're doing yourself a disservice. Sometimes we need to be aware of what is feasible at the moment and not let those opportunities go by, because each time you do, then you miss yet another opportunity to advance in the right direction. So thinking about those things and those dynamics and what government agencies we can work with and which ones are in a position to address a certain issue is just as important as getting that victory or in the process.
I'm wondering if people could talk a little bit about the tension that appears between the need for flexibility, especially in a changing climate where we don't necessarily know what the precise impacts are going to be, where they're going to be, or what mechanisms are going to be effective or cost effective, and having a clear law that can be enforced and implemented, and that it's being implemented and enforced. How do you manage that dynamic tension? And I'm thinking about instances where laws have tried to give government agencies flexibility, and then a new administration comes in and says, oh, great, I've got flexibility to do nothing, or to kind of sell things off, or to do things that might not have fit the spirit of the law.
If I can intervene on this. Thank you. This is a crucial issue regarding the development of climate legislation, because a successful response to climate change, of course, requires flexibility to adapt to the new challenges, but at the same time, the need to ensure compliance is also at the top of the priorities. So what we have seen when developing climate legislation with countries is also that it's very important to include in legislation, so to embed in legislation mechanisms for the periodic review of laws to adjust to the new developments. So if you embed the formal review periods for reviewing laws, for example, let's say every 5 years, the legal systems allows for this flexibility, and at the same time it maintains the predictability that a law needs to ensure. And at the same time, the need to ensure the enforcement of this law. So the gap between development and implementation and enforcement of legislation is also a crucial issue to address when developing climate legislation. And here as well, the climate law should include clear legal obligations for enforcement and processes for agencies and governments to follow up on what is established in the law. So is this law being effectively implemented? Mm-hmm. So, for example, by establishing monitoring mechanisms to monitor the compliance with what is established in the law, for example, through independent oversight bodies that can ensure that there are reporting mechanisms on the effective implementation of this law, and sanctions, of course, for non-compliance. So if the law is if the non-compliance is then reported and ascertained, there should be sanctions for take care of this. Yeah, thank you very much. That's all.
Thank you, Valentina. Daniel.
Yeah, so in part, it's our responsibility. When I say our, it's in all of us. It's in all of the people that are focused on these issues. We are privileged to have a lot of information about a lot of things, and sometimes we fall a bit short in seeing the big picture. And so going back to the issue of the climate emergency, we were talking earlier about the fact that we're not on 1.5. Well, the science has adjusted. If you read AR6, you know that decarbonization is not enough. And you need to focus on things like methane, which is 86 times more potent than CO2. You need to focus on HFCs, which are refrigerants. You need to focus on black carbon, which also has a huge health impact. And the politics has begun to go in that direction. And you've heard, I speak about our three presidents, the Biden administration, Trudeau, and the former several Mexican administrations focusing on methane. And you see that things are going in that direction, right? And you see things like disclosure being discussed and how the corporate sector needs to adjust. And so it's your responsibility as the folks in the legal box to read the tea leaves and see where that's going. And when you make those choices about where you're going to focus your litigation, to also understand that the legal box takes a long time to come into sort of the groove of where the puck is in the hockey game, right? And so we need to step back and look at that big picture and be the ones reading where the priorities should be, so that when you are at taking action and asking or litigating or pushing an issue within the legal box, that it is in line with the evolving science. It's probably going to be ahead of the game, and we are going to be behind on the policy side, and then in third place, the legal side. And so there's a challenge there, right? But we all need to be thinking about that big picture, because if you've just latched on to some issue that you really want to focus on, but you're not in the right framework, then we get into that intergenerational equity paradox of where you're making the wrong decisions about where you want to put your focus.
Fantastic. Yeah, Carl, did you have another?
There were a couple of questions I wanted to lump together. Basically, people were in the Q&A, there were a number of questions about finding information on different cases. And I'm wondering, maybe Maria Antonia or others would have suggestions for this. There's a question about finding notable cases from around the world issued by domestic courts, and specifically applying international laws or standards. There's another question about, are there any articles about cases in the Dominican Republic? And I'm wondering, if you could comment on available resources where people could find or search or review relevant climate legislation, climate litigation, and decisions.
Sure. So definitely have a look at the climate litigation database. I put it here in the chat. I can put it again, which has all of the cases that we are aware of so far. I'm certain that there are more that we are not aware of. So for the Dominican Republic, for example, there are no cases yet, but if you're aware of some cases that it's not there, just please let us know and feel free to contact us. We do have a network of people around the world who help us maintain the database. These are experts in climate change, climate law, climate litigation in their own jurisdictions, and they let us know about what's happening. So if there are still a couple of countries that are not represented, so if you want to join as well, you can reach out to us and represent some of those jurisdictions too. The UNEP report on climate change litigation, I think it's a good starting point to understand climate litigation and the general themes that appear. So we're likely going to start the process of doing the follow-up of that report. So that was the third report we published last year. So we're going to start this process soon of, probably in the beginning of the year, we're going to start writing the fourth report on that. Like I said, things are constantly changing. The Sabin Center also has a climate law blog, which, sometimes when there's something very new, we do sort of quick reflection points about those cases or decisions on the blog. So I can also put the link into that. You know, I'm constantly writing about all of those things. So, you know, I try to share everything on LinkedIn and on Twitter as well, of everything that the Sabin Center is writing on climate litigation. So things are always happening.
Lisa.
Yeah, just to add, I'm also a member of the Environmental Law Alliance Worldwide, and you know, it's a wonderful group of people or lawyers around the world. You know, we're very active in any, you know, many environmental cases, and so they have a website also on cases, and also on laws, and domestic laws on climate change. And maybe you can also get in touch with some, by asking them questions about maybe environmental lawyers in the Dominican Republic, who are also engaged in these cases.
So we still have a couple of questions that have come through in the Q&A and in the chat. One of them is specifically about funding for climate adaptation at the international level, and whether we might see adequate funding decided in COP29 in Azerbaijan. I'd like to take the liberty of expanding this question a little bit, and just opening the question of what role does funding play in ensuring environmental rule of law in the climate context? And what can we do when funding is not sufficient? Yeah, Antonia.
I can say a little bit about funding for climate litigation, which I think is, you know, obviously my area of expertise. So there's definitely an imbalance, I think, of sort of where the money flows in. I think, you know, funders of climate change litigation are trying to address this in the last couple of years. And now there are a lot more cases in the Global South, for example, where, you know, the money wasn't really flowing to very often. Obviously, it also depends, like there are, I think, more of the like systemic cases that are really trying to change like mitigation goals, and in a country are mostly addressed at the global north, mostly because emissions are coming mostly from the global north, right? So there's that part of the issue as well. So money is going in that direction because that's where there's also more money for these measures, right? But you know, but I think, you know, it depends a lot on obviously on the environmental rule of law and sort of the resources that each country has. Brazil, for example, has a public prosecutor's office that is very active in bringing, you know, was always very active in bringing environmental cases, and now is very active in bringing climate cases. So it depends a lot on sort of how the legal system works. So these are other ways in which, like when there's no direct funding for certain cases, it could also be an option.
Daniel?
Yeah, well, funding is just short. It's not enough. We're way short, right? And so we need to make some tough decisions about what is funded. And going back to one of the questions I tried to answer in the chat or in the Q&A, what you fund is important. And the balancing between the mitigation and adaptation is critical, but we shouldn't look at it as either or. Sometimes mitigating can also be adapting. You know, if you're introducing nature-based solutions to introduce reflectivity, bringing trees into an urban heat island area, for example, or have absorptive surfaces that help with water capture and making communities more resilient by building up biodiversity, which is also capturing CO2. I mean, these are all solutions that do both mitigation and adaptation. And so legal actions and rule of law around actions that could help do both are critical and important. It doesn't mean we should ignore that which isn't mitigation. But again, with a limited budget, you have to choose your battles carefully and figure out which way you want to direct your energy and your resources.
Yeah. I have one more question of my own, and we're getting to the end, so I'm going to go ahead and ask it. And this is a very selfish question because it relates to some of my own research interests. What is the connection between environmental rule of law and a just transition? And Maria Antonia, I know you worked in this area, and I expect many of us have thought about it since just transition has become very much a topic on both at the international and national levels. So I'd love to hear your thoughts.
Yeah. I mean, I think this is a big question too, because a lot of people will say, let's just go back and what is a just transition and what does it mean? The way that we see it, we did some research looking at just transition litigation cases, particularly in Latin America, and now this research is expanding a bit to other parts of the world. But I think the big question here is, as we're doing this big energy transition, right, are we complying with the human rights? Are we respecting the human rights of people that are affected by this transition, right? So these can be, I think traditionally this was thought of as the workers that are, losing their jobs because the oil companies are, or mining, the industry is changing, right? So they don't have the same opportunities as they had before. So, how can we better prepare them for jobs in, renewable energy or something else? But as we started looking at the cases that actually exist, this was a lot more focused on, excuse me, on indigenous groups or traditional communities that are being impacted by certain projects, like either mining projects for like lithium or other batteries that are necessary for renewable energy, or even like a solar panel or something like that was near a certain community. And these are usually related to vulnerable communities. So there are also cases brought by women and children. So really like looking at how these human rights can be respected as we do this energy transition, because obviously we want to do the transition fast, but we want to do it right and not just replicate the same mistakes that were done in the past, right?
Yeah, definitely. Daniel.
Yeah, just adding to that, I think Maria really summed that up well. I mean, just because you're now focused on a climate project doesn't mean you're doing things right, right? So if the way we've organized to do an extractive project already had inherent biases or systemic racism or unfairness to certain communities, there's no reason that now focusing on a solar park is going to do any different, right? And so the just transition implies that yeah, we're going to cleaner energy, but are we doing it in a sustainable way, right? That's the first issue. The other thing, and I mentioned earlier, right now, the flavor of the month and probably of the decade and probably the century is climate change, right? And so that is raising a whole series of new questions about, in the current predicament, in the current impact that we are seeing of climate change, who is affected? And we're all of a sudden having all these sensitivities to these intersectional dimensions of environmental justice. And every one of those is taking all of a sudden some of the light in this discussion. And we're moving away from just focusing on human rights and environment to focusing on climate change. And so some of those actors that used to focus on EJ, for example, are now either morphing into a climate justice framework or some sort of other type of justice related to the climate emergency. So you have groups like youth, and you gender groups and migrant and labor. And I mean, there are a whole bunch of things. And energy is one of those pieces. And so in these new voices you're hearing, this is one of the new flavors of advocacy that we need to think about. But we shouldn't lose sight of the bigger picture. And this is what I think Maria was getting to. Just because we're doing a solar farm doesn't mean we've addressed all of these sustained issues that we haven't really resolved. And that's where the discussion should be focused.
Lisa, sorry.
Yeah. Just to add, I think as we're racing towards just transition, we're also, as we've heard, impacting a lot of communities. And but what I've seen is that we're also using still the traditional tools such as environmental impact assessments, but not really, maybe we need to develop, newer environmental impact assessment tools like, the climate impact assessments and cumulative impact assessments. So we better improve the way we assess the impacts of these projects to our communities, and so we can have this, the just transition that is grounded in justice as well as in equity as well.
Yeah. So we're about to close, so I just want to give all of our panelists 1 moment to give us a last thought on any of the topics that we've discussed. Okay. Well, everything has been said. Did you have a last thought for us?
So no, I just wanted to thank everyone for, well, yes, Daniel has a last thought, so I'll leave it to him.
No, I mean, in addition to thanking everyone, I think it's important to put everything in perspective. I've been around this issue in advocacy and now in a diplomatic organization, and we are progressing. We are making progress, right? There are gains, but we do need to realize that these are staged, and it doesn't all happen in a single moment. It's a process of time and looking at what is happening around us and trying to see that big picture and taking the pulse of what we're seeing and trying to contribute. And I think everyone that is involved, everyone on this call, but also our colleagues, we're all trying to do the right thing. We just don't always put things in that perspective. And when you've been around for a while, you've seen a lot of things, kind of like the insurance commercial, right? You've seen a thing or two. And you do start getting a pulse of where we're going. We're going in the right direction. We're just not going fast enough. One thing I always say at the beginning of most of my presentations is, whatever we think we're doing, it's not enough. We need to do more. The question is what to do, right? And that is just as important as what we are doing. And so just to think about that and to have some hope that we are somehow collectively working towards a common goal.
Yeah, I think that's a fantastic place to end, with hope. Sarah put an invitation in the chat to our next in this webinar. So let me close by thanking all of our panelists, thanking ELI, Sarah and Madison and their hard work, thanking Carl, my co-moderator, and thanking all of you for joining us today.
Thanks, everyone.
Thank you.
Thank you, everyone.
Thank you.
Thanks from ELI. Bye, everybody.